What started as a routine court appearance quickly turned into a tense discussion about responsibility and accountability. The judge revisited the defendant's previous statements, questioning whether she truly accepted her role in the incident. From the very beginning,
it doesn't matter if you were pulled over for listen to me. This is why we're hearing stuff all over in the news. It doesn't matter what you think. If a cop pulls you over, then you take the ticket for not wearing your seatbelt. This is all over not wearing your seatbelt. And here you are in felony court and you're still not taking responsibility.
Because she didn't accept responsibility for a crime.
Uh-huh.
And then we came back and she did accept responsibility. So we repled for the same.
Okay.
There was a different attorney involved on the first time when I was appointed.
Yeah, she pled in May of last year.
As the conversation continued, the judge focused on a simple question. Could this entire situation have been avoided? According to the court, a routine traffic stop escalated into a serious felony case because of choices made in the moment. The judge repeatedly emphasized that compliance could have prevented everything that followed.
With full deferred time or back.
So nothing else was done as far as them talking to Miss Johnny about acceptance of responsibility.
The only thing Miss Johnny said, they called and asked her for her updated address, and that was it.
Okay. So, Miss Johnny, I'm going to ask you again, and I know we probably went through this before. First of all, you're Kirsten Johnny. And Miss Johnny, I want to make sure, because in that previously you said you didn't do it, you were forced to do it because of your financial, you were forced to plea because of your financial situation, that it wasn't fair. And so tell me what your position is now.
The courtroom grew noticeably more intense as the judge challenged the defendant's reasoning. The message was direct. Disagreements with law enforcement should be handled through legal channels, not resistance during an arrest. What began as a seatbelt violation had now become a felony case, carrying life-changing consequences.
You were not complying with what they told you to do to get out of the car, correct?
I was pulled over because I was in the high. I stay in the area. I was pulled over because.
Hang on. Don't talk yourself out of this again.
Because if you want to talk yourself out of it, we'll put it on the trial docket and we'll get it done in a few weeks and let a jury decide. I'm trying, look at me. I'm actually trying to help you right now. Okay?
If you had complied and just done what he asked you to from the very beginning of that stop, none of this would have happened. Do you agree or disagree with that?
Yes.
Yes, what?
Yeah.
No, do you agree? Listen to the question. Do you agree with that statement or do you disagree with that statement?
I don't know why.
At this stage of the hearing, the judge made one final attempt to determine whether the defendant truly understood the seriousness of the situation. After reviewing the evidence and hearing the arguments, the court emphasized that accountability is often the first step toward avoiding even greater consequences in the future.
Wearing your seatbelt. This is all over not wearing your seatbelt. And here you are in felony court and you're still not taking responsibility for the fact that he said, hey, ma'am, do this. And you said, I don't think you should have pulled me over, so I'm going to do whatever I want to do. And I'm going to lodge my foot against the door, and I'm not going to get out. I'm going to make you drag me out of my car, and then I'm going to kick you because you shouldn't have pulled me over in the first place. When all you had to do was get your ticket, go to JP court, and try to fight it there legally. But here you are in felony court for a second-degree felony instead. So do you want to try to tell that story to a jury, or do you want to accept some responsibility today?
I don't feel like one.
You don't feel like going to trial. Well, there's two parts to that question. Do you feel like accepting responsibility?
With the plea agreement accepted, the judge delivered the decision. Instead of a felony conviction, the defendant was given an opportunity that many people never receive: deferred probation. The court made it clear that this was not a reward, but a second chance that would require strict compliance with every condition moving forward.
Be pleading to this from what you saw?
I do.
So, I mean, you even saw how you acted. It's probably a good idea. All right. I'm going to find that you previously entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney. I hope you prove me wrong on this, because I really have some concerns that you're going to be able to be successful, because you're not taking responsibility and you're not wanting to follow directions and things like that. And you're about to have 4 years of having to follow directions on probation. So I'm going to defer all proceedings for 4 years. You're ordered.
The warning that followed was impossible to ignore. The judge explained that any violation of probation could bring the defendant back into court, where the consequences could become far more severe. What was being offered today was a chance to avoid a felony conviction, but only if every rule was followed without exception.
The other side to that, though, and this is really important for you to understand, because we've had this conversation now so many times, I'm not likely to forget you. And you can ask anybody, and Ms. Holmes has known me for a long time. It's not usually good when I remember people, right? So if you violate your probation, you'll get brought back into court. You could be found guilty, which means you become a convicted felon, and I can sentence you to prison anywhere in the range of punishment, which is up to 20 years in prison for this. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will go over your paperwork as soon as they're ready.
Okay, when you said that I'm not considered a conviction felon, but I was told that even though you say that, it's still going to be on my record.
So the arrest is on your record. The arrest will always be on your record. But so if you're asked a question on filling out an application for a job or something.
As the hearing came to an end, the court clarified an important point. While the arrest would remain part of the defendant's record, successfully completing probation could prevent a felony conviction from ever appearing on it. The judge's final message was simple. Opportunities like this are rare, and what happens next depends entirely on the choices made from this point forward.